The members of the committee present today. To my immediate right is Mr. Ilagan. To my far left we'll have Mr. Onishi be joining us shortly, Ms. Willie, Ms. Poindexter, Ms. Ford, Mr. Yoshimoto, Ms. Eoff, and Mr. Kanuha. I am Zendo Kern, the chair. And also note, before we begin, I'd like to make a note that those in attendance regarding communications 880 and 881, please be advised that the nominations forwarded by the Planning Committee by these communications have been withdrawn by the administration at this time. Therefore, no nominees will be present today. Members may refer to the letter from the director in your folders, which are also available to the public. This was sent after the agenda was posted. We look forward to the resubmission of nominees at a later date.
A point of order?
Yes, ma'am.
Chair, are we allowed to comment on these withdrawals and what's in the letter?
We will not be.
That's not allowed?
Correct. We will not be.
Okay, so the department can just remove it like that without
that'll be up to me.
Oh, okay.
It's going to come to me and I'm going to withdraw them, and we're not going to get in a conversation on it.
Okay. Okay, so I'll save my comments for a future date.
Thank you very much. Okay, with that, we'll start with statements from the public on items on the agenda. Statements are limited to 3 minutes. Check in Kona. Are there any testifiers in Kona?
Good morning, Chair. We have no testifiers in Kona today.
Thank you very much. Ka'u?
Mr. Chair, we have no one to testify in Ocean View today. Thank you.
Thank you very much. And Kohala?
Good morning, Chair Kern. We do not have any testifiers for your committee.
Thank you very much. And Waimea?
Good morning, Mr. Chair. We have no testifiers. Thank you.
Thank you. And Pahoa?
Good morning, Mr. Chairman. We have no testifiers in Pahoa.
Very good. And here in Hilo, we have one testifier. Thank you. We have Carrie Marks commenting on Bill 182. Give us your name and you may begin.
Good morning, everybody. I'm Carrie Marks from Kaumana City. I'm here to testify on Bill 182, which is about having the planning director or his designee do site visits before they approve a plat map or any new subdivisions or anything. I think this is a fabulous idea. To be honest, the planning department staff is wonderful. They really do a good job. I have been to almost every planning meeting for the last 2 or 3 years, and they really do a great presentation. But how they figure out where a subdivision is or where a new road is supposed to be is they go on Google Earth and they post up a picture. They do a really nice PowerPoint presentation on the slide. And you can see quite a bit from the Google Earth map, but what you cannot see is the actual neighborhood and the actual conditions. I think it's a different experience when you go to the actual site and you listen and you hear what the neighborhood is like, if they have coqui frogs or not, if they have traffic or not, if they have noisy neighbors or not. Those kinds of things would not come out on a Google Earth search. So I think an actual site visit to the actual site before they approve a plan to change the zoning of the site is a very good idea, and I support that. That's all. Mahalo.
Thank you very much. Is there anyone else wishing to give testimony at any of the locations? Hearing, seeing none, public testimony is now closed. We'll move on to items on the agenda. Mr. Clerk, will you please read in communication 880 and 881?
Communication 880, nomination of Ms. Veronica Lani Eugenio to the North Kohala Community Development Plan Action Committee from Mayor William P. Kanoy, dated May 5th, 2014, transmitting for the Council's review and confirmation the above nomination. Communication 881, nominations of Ms. Fanny K. Ahoy, Ms. Nancy E. Burns, and Ms. Carrie L. Kimura to the Kona Community Development Plan Action Committee from Mayor William P. Kanoy, dated May 5th, 2014, submitting for the Council's review and confirmation the above nominations.
Thank you, Mr. Clerk. At this time, communication 880 and 881 are withdrawn. Mr. Clerk, will you please read in Bill 182?
Bill 182 amends Chapter 23, Article 4, Division 1, Section 23-61 of the Hawaii County Code 1983, 2005 edition as amended relating to site visits for applications for subdivisions. Prior to approving or disapproving a preliminary plat, the planning director or the director's authorized representative shall conduct a site visit to the designated property to verify that the information within the preliminary plat and its supplemental materials is accurate and complete, and also to determine if there are any conditions that warrant revisions to the preliminary plat. Revisions would be made by the subdivider after consulting with the planning director. Reference Communication 603, introduced by Ms. Ford, referred to the planning director and planning commission's January 21st, 2014. And Communication 603.2 from Mayor William P. Canoy, dated May 2nd, 2014, transmitting unfavorable recommendations from the planning commissions and planning director.
Thank you, Mr. Clerk. May I have a motion to approve Bill 182 and send to council with a favorable recommendation?
So moved.
I have a motion by Ms. Ford and a second by Mr. Onishi. Ms. Ford?
Yes, and I'd like to amend that motion to also file all related communications.
That is noted, to file all related communications as well.
Thank you. Obviously, I initiated this site visit because of the many problems that we've had over the decades with inappropriate types of development. And when I say inappropriate, it's not that they're in the wrong zone or anything. I say inappropriate because they're not, the planning department does not consider, nor does the planning commission consider the, shall we say, the lay of the land, and as Ms. Marks eloquently put it, the ambiance and the changes that it will be occurring in the neighborhood. The worst example I can give you is what we call the Missler case in my district. The Misslers had to sue the county for numerous violations of our charter and our codes and state law. Hundreds of thousands of dollars have been expended. The Board of Appeals would not listen to reason. I personally tried to get the land. It's on the PONC list. I tried to buy the land and stop the lawsuit before it started. And it's now on appeal because of not just the planning director, because a corporation counsel attorney came in and said, you guys have no status, and we put a resolution through and said, don't appeal this thing, and they went right up ahead and did it anyway. So instead of just hundreds of thousands of dollars, there's going to be more money. Eventually the bill is going to come to the county and we're going to have to pay it. And they've lost, the Misslers won in court, and so between the planning director and the Board of Appeals making bad decisions, we're wasting all kinds of taxpayer dollars. Had anybody gone out and looked at the land besides me, I seem to be the only county employee that went out and looked at this, we never would have said yes to this whole thing. We would have, and the planning commission, unfortunately, for the most part, rubber stamps everything that the director says. So I understand the planning commissions do not support this because the director doesn't support it. And I'd like to call the director up at this point, the current director. He was not the director involved in this. And so if you read the reports from the planning commissions, they're just normal for them. But one of the things I found interesting in reading those reports, Mr. Kanuha, Director Kanuha, was that you were recommending that the preliminary plat be required to be done by an engineer or an architect, and they refused to put in your recommendation. But it's in there that they're refusing. Would you explain that, why you thought that would be important and maybe alleviate some of my concerns on this bill?
Thank you. Good morning, members of the Planning Committee. Dwayne Kanoa, Planning Director. The way the code reads now, a subdivision goes through 2 steps. Okay, you submit what we call a preliminary plat, which is a layout of how you want the lots divided, roadways, easements, whatever. And then upon approval of that plat, if there's construction required to put in a roadway, water, things of that nature. Once the preliminary plat is approved, then you go ahead and you get the construction plans to put in those improvements. Some subdivisions don't have any improvement requirements, okay? Then what you do is you come in with a final plat, and that's the one that's approved for recordation with the Bureau of Conveyances, etc. The way the code reads now, that final plat has to be prepared by a licensed, registered surveyor or engineer. The code doesn't make that requirement for the preliminary plat. But in my experience, 95% of the preliminary plats are prepared by a registered surveyor anyway. Particularly nowadays, because the properties that are left to subdivide are not the really easy ones, where you can just go in there. There's a lot of complications for them, so that's why I think we see a lot more preliminary plats coming in by registered surveyors.
Excuse me, thank you. The concern that I have, though, as one of our council members has stated numerous times, is that the plat that comes to the council that we look at has absolutely no relevance to what we're deciding on, which is basically a density issue. I don't personally agree with that, but it's been stated numerous times. I don't see why having an engineer do all of the preliminaries would make any difference, because, for instance, there was a case, I'm going to try not to mention the name. We had one that came in, and I said, this project is one way in, one way out, and there's a couple hundred of these residential units, and the fire department was upset, and there was all kinds of other issues. And that's perfectly okay. I mean, they could have submitted, as I said, a design for a rocket ship, and it wouldn't have made any difference. And I find that, one, is offensive, because and secondly, they're not drawing these things to take into consideration all of our codes. So we're getting things that get me very concerned, because it's a public health and safety issue. And I don't have any confidence that when they submit the final, that those things will be taken into consideration. Remember your rule of thumb about streets that I wanted to put in the code, and you said no, and nobody except me wanted to vote for it? None of that stuff's in there. They always come in with the maximum of everything and see what they can get out of the county, and they usually get a whole bunch. So I'm not seeing why having an engineer design the preliminary is going to make any difference at all in protecting the public from these unsafe developments. Can you respond to that, please?
Sure. The council never sees a subdivision plat.
That's true.
Yeah, that's all administrative. What you're talking about is
The rezonings.
Yeah, the entitlement step before that. Rezonings, etc. And so there's no survey if there's any subdivision involved. Some of these projects don't involve subdivisions. You may just have one lot that's being converted from residential to commercial. So there's, no subdivision involved. I think the one you're talking about was like that.
That's
there was no
right.
subdivision involved. In cases like those, there's a required process in the zoning code called plan approval. And where there are specific requirements in the zoning, like for additional landscaping on the side of the property that has a residence next to it or something, okay. Those are over and above the normal conditions that we would do for plan approval. But because they come down to the zoning code, when that project comes in for plan approval, it has to do those specific requirements of what the council approves as a final zoning. So, that's, the council never sees, the final subdivision is all I wanted to say on that. Yeah.
Well, at this point, I see you have not answered my question why, and having an engineer doing the preliminary plat, which comes to us on a rezoning, is going to make any difference at all.
Well, there's no preliminary plat. The only thing that comes to you on a rezoning is a perimeter survey of the area that you're rezoning. Yeah.
Okay, that sort of fits into what my concern is and why I'm asking for a site visit. We see nothing of consequence on a rezoning, and the planning department doesn't go out to look at the property to see if there's something really drastically wrong, like giant ravines on the property where you cannot build. So that's the reason I want you to go out to stop, hopefully to stop some of these ridiculous lawsuits that cost the county and the public a great deal of money. And yet you're saying you don't want to support that.
The planning department does a field inspection for every rezoning we do. If you ever attend one of the planning commission hearings where we do our presentation, it's a very extensive, there's a Google Earth, there's site plans of what the property is going to do, there's zoning overlays, there's general plan overlays, there's community development plans overlays. We site inspect every single property.
Then how do you explain putting a subdivision on ravines?
I beg your pardon?
On the Missler case, how does the planning department justify allowing that to go all the way up through the Board of Appeals and miss everything that was on the property? Ravines, endangered species, everything got missed. And yet the neighbors submitted all that as information.
Yeah,
how does that happen?
Yeah, my understanding was there wasn't a site inspection for that property.
There definitely was not a site inspection except by Brenda Ford. And I testified in front of the Board of Appeals as to what was there, and they wouldn't listen. So that is the reason that I'm putting forward this bill for a site inspection on these things. I think it's important. And the council, I know what the council's going to do. That's the reason I'm doing it, to protect the public from ridiculous lawsuits.
Okay. And again, to clarify, what you're asking for is the site inspections for a subdivision. The incident you're talking about, the precursor to that subdivision was a PUD, correct? It was a planned unit development.
And don't get me started on that one.
Right. Well, the PUDs don't require a site visit. Since the Missler case has come along, I require a site visit for every PUD that's being processed.
But Director Kanuha, and I appreciate that you're now requiring that, and I sincerely mean that, but you aren't going to be here forever, and the code will be here. And if somebody else comes in and replaces you, they might not be willing to send somebody out to do the work that you're willing to do.
Yeah, well, I think when I first came on, we had some discussions about PUDs. I don't have a problem with the council requiring a site visit for PUD. I really don't, because there's so few and far between. They're actually a form of several variances. I don't have a problem at all with that being a requirement, and that's why it's a requirement, and it's an administrative requirement that I'm imposing. So.
All right. Well, I wish the council would reconsider and do this. I wish the council would reconsider their past votes and do this. It's to protect the public. It's to protect the county. And I think there's several other places that site visits should be required, PUDs being one of them, rezonings being another one. But, I know how this is going to go down, but I'm going to vote for the public, so thank you.
Thank you, Ms. Ford. Ms. Eoff, followed by Ms. Willie.
Okay, thank you. So I think what it comes down to is the planning department and the planning commission is concerned that if we were to require a site visit for every single rezoning that came before us or before them, that some of that would be unnecessary. And so they offered a compromise situation to us and suggested that we amend the code to require a licensed engineer to provide the initial site study for I guess, to alleviate a case like the Mistler where somebody's never saw that there was a ravine or something. But there's other fixes that are coming along the way too. Mr. Kanuha has now told us that, Director Kanuha, that some changes to the code regarding the PUD. So I'm not sure whether, I like the intent that Ms. Ford has brought forward in this bill. I'm not sure whether this is the bill that we need to support or if there's other ways we can do it without causing too much unreasonable work. Is that kind of where you're trying to help us understand as well?
Well, for subdivision.
Microphone, please.
For subdivision, the actual partitioning of land is what it is, okay? It ranges all the way from someplace in house lots or a residential community in Kona, all the way to several hundred acres in maybe Waikiki, Waikoloa, all the way to several thousand acres in Ka'u or, Mauka Kona. So I think what it comes down to is how do you site visit 100-acre parcel, and based on that site visit, have enough wherewithal to determine what's a potentially deleterious effect to the general welfare and health of the community. There's the PUDs, which are like variances. Okay, they're discretionary permits that are handled within the department. And then there's subdivisions, which are purely ministerial. Council never sees those. The same with PUDs. So I just want to be sure that you understand that there's different levels of review and there's different levels of input. The subdivision is the most precise, because it requires precise surveying. It requires precision because what it does, it ends up describing a property that has to be recorded, and that goes into a deed that transfers onto somebody else. So it's ministerial, it's pretty precise. The PUD is a discretionary permit, like a variance, that is handled within the department. And, I don't believe that it's a perfect process. I think we've talked about, ways that could be improved. Because that way it provides a better link between what the department actually approves as a PUD that translates into the subdivision. So if you get kind of a junky PUD or PUD that wasn't well thought out, or the decision on that wasn't that good, if it translates down to the subdivision, then it just makes messy legislation all the way down. So I'm not adverse to fixes to those particular processes. And then for the rezonings, the applications that you folks see, staff field inspects every single one. Every single one.
Thank you. I tend to agree that we can do some fixes too, especially the approvals of PUDs that would require site visits and other is there that would, I think, be a good step towards this direction. Again, I think Ms. Ford for bringing us to a public discussion, and I think we can.
I think over time I work with, we've had discussion with several of them, changes that you may want to do with it, etc. So
Appreciate that. Thank you.
Thank you, Ms. Yap. Ms. Willard?
Hi. Yeah, a couple comments. I think one of the problems that I have is where it would be every lot. I know I've handled, let me just say, one where it was, and I'm talking about it, 400 acre parcel being divided to 200 acre parcels. I wouldn't want to be spending taxpayer money to go out there. On the other hand, I take a look at Puaco 1010, which actually came to like the action committee as a subsequent PUD. And one of the big arguments was, well, you really ought to go along with this PUD because you should see what a disaster it is as a subdivision if you go out and look at the land. And I'm going, well, why did we allow what even the department person was describing? I'm not sure they used the word disaster, but you know, it's not good. And I would have really liked somebody to go out there and see where these ravines are and where this is, and realize the erosion that's going to now result down on the other side, you know, in Puaco. So, you know, if there was something here that wasn't everything, and I was trying to think, you know, where appropriate, or you know, what language, I would be supportive of something that actually would provide for that under some conditions. I wouldn't favor an every, because I just not cost efficient. So I'm not sure I'm going to vote in favor of this, but I support the idea, and I see some real disasters where that isn't done. I do want to say that I disagree with you in terms of just characterizing subdivisions as ministerial, and in some places it's considered ministerial, in some places it's discretionary. In my view, is there discretion involved? And that's really the ultimate question, and there is discretion involved there in terms of what is permitted. So it may be more there's a continuum, and it's more ministerial than say the zoning. And in zoning, we say, really, should it be in this category or that? But what tends to happen is, well, what's the use that you're planning on? It's not just what category you're going in. It's, you know, Waimea 2020 plan, and should be this commercial or residential? No, well, exactly what are your plans for use? So I think each of these categories tends to be, I don't know, multifaceted. So I also have, in terms of your discussion of preliminary plan versus final plan, back in, I think it was 2006, there was a court case, and the County of Hawai'i lost based on not providing enough information to the public so they could comment on the preliminary plan. I'm trying to think what the name of that case was, with Chris Ewan, and he came in. Isabel was in for that time. And he said we need to eliminate this requirement so that all of these other subdivisions we're holding up aren't compromised. And I, you know, challenged that and said we need to do certain things to allow for better comment so the public knows what's going on. If you look at this and you look at the code, it doesn't say show the improvements in that preliminary section. That requirement was taken out. So, and you know, the director then said, okay, I need you to take care of this, and I'll go on and deal with what Margaret says at a later date. It never happened. But I do think looking at what's in the preliminary versus final is an important issue, and something that I would like, you know, I'm not going to harp on it now, but it really is at the preliminary stage that I feel that's where the public or the action committees can come in and speak to this, and that it's good to have as much information as possible at that level. So anyway, I just want to make those comments, and let me say I would support something that provides for site visits, but not necessarily at every one. So I'm not, if I was diligent, I'd probably have an amendment here to put in, and I don't have one, but I'm going to yield at that point. So I don't know whether Ms. Ford wants to comment on this and respond to my
You know, just a comment that the code requires a posting of notice on every property that has a subdivision application. And then we also post a notice in the newspaper of all of the applications that are pending.
Okay, but a lot of times, those notices aren't where everybody can see and know what's going on. I can give you some examples of that, and it isn't something that, I just feel that when it gets to the action committees, that should be where you get that kind of discussion and have that information. But anyway, that's on another subject. Thank you.
Thank you, Ms. Willie. Anybody else for round one? Ms. Ford?
What I'm about to say, I mean with all due respect to all council members, but I'm really discouraged because when somebody else on the council brings forward a bill and I don't quite agree with it, or I think something needs to be tweaked a little, I write an amendment. And I've always been willing to compromise, always, on my bills or anyone else's. But what I see here is when I have this bill, everybody trashed it at the committee meeting. This is the first time I've heard anybody say anything about, well, maybe if it didn't say every single subdivision, we could handle it. Nobody wants to do any amendments to my bill. And I think, I'm not sure if we vote this down today, is it a dead one because it came with a negative recommendation? Okay, thank you. Sorry, I had to check the chair. Goes up one more time. Okay. But if it gets a negative vote at council, the first time it's gonna go down, right? Okay, just wanted to clarify that. It's not like I'm unwilling to compromise on anything. And I look at the comments from the planning commission and I see they all gave it the thumbs down and then they refused to put the director's comments in on how something could be improved. I find that really, really distressful. You know, that's what they're supposed to be doing. They're supposed to say, well, we don't like this and we recommend that, and by the way, the director says, hey, have you considered this? That would have been a much better bill if I couldn't have done it all in this one bill, but that's information that I think the council is entitled to. I value the director's opinion. No one always agreed, but I do value your opinion. But, you know, I look to this council, if I've missed something, then I look to my team here to say, Brenda, I think you missed something and maybe either I'll do it, me personally, if you tell me about it here at council, or you're willing to do it on your own. I write lots of amendments for everybody else's bills and most of them get accepted because we're supposed to be working as a team. I write a bill, nobody does anything to help me with my bills and tweak them, and then they trash my bills. So I'm really distressed about that. If this council wants me to put some language in here so you don't have to go out every single time, but I'm willing to listen, just give me some ideas what that language should be. I'll talk to you too, Mr. Director Kunaha. I'll amend it. I don't mind amending things, but it's really, really distressful to do all the work and you catch something and just say, let's just kill our bill.
Thank you, Ms. Ford. We're going to go to Ms. Poindexter, then Ms. Grobnici, and then back to Ms. Wood.
And, you know, I feel bad that Councilmember Ford feels that way, but, you know, I'm not making my decisions based on because it's your bill and you help me with mine, so I don't recall any of that happening with me anyway. And I remember some things maybe council members did not agree with me, and that's why we work as a team. We agree to disagree on things. And what I heard from Councilmember Eoff is that she's currently working on something which she cannot share because of the sunshine violation. So I hear the discussion that to me is moving in a positive direction, that some people are looking to address this. So it doesn't necessarily have to be a bill that I write and that I feel Margaret or Zendo, you guys should help me out with that so my bill can pass. It's not about me. It's about what needs to be done overall. And it doesn't matter who it is, but what I'm hearing in the discussion is I'm hearing that, you know, we want to work on some things that, you know, PUD versus what is here, what may not work well in this bill, but that would work better with maybe that something Karen is bringing forward, which she can of course discuss, but we talked about a little bit about that, about where should that be visitation. You talked about that too, Councilmember Willie, about you don't see it being in that, that every parcel, and this may bring some problems. So it's not about, you know, with no disrespect to you, Councilmember Ford, it's not just about you and your bills feeling, you know, we all have a voice, and yes, as a team we vote on what we need to do, and yes, we are a team and we can agree to disagree. So I just want to say that I just want to hear more too, and I feel with what I've heard already, I don't feel comfortable with voting on this bill, but looking forward to more of seeing things happen more with the PUD side and some other things come forward. So I just don't want the public to think that we're not working as a team or ganging up, and you know, and we all agree that, you know, our expressions and what we show on camera. I've had emails come forward and say, you know, watch your expressions because you're caught on camera and all, and the public is perceiving that. I just don't like that, the public's perception to be a not good one, that we're not having our own voices. But anyway, so I'll yield at this time.
Thank you, Ms. Poindexter. Mr. Onishi.
Thank you, Mr. Chair. I had a question for Ms. Ford, if she could answer this for me, please.
Ms. Ford?
Have you checked with the planning department when you came up with this, and did they give any recommendations about this amendment?
Not to me, they gave it to the planning commission.
Well, I understand, but did you work with them?
I have talked to Director Camillo and told him I'm not happy with this. So the only discussion we had is I'm not happy with the site visits not being made, that's it.
Okay, so to me, if we could have a dialogue with them, then maybe this amendments that you're trying to do, we could pass. But if you're not gonna have a dialogue with them, because we're hearing that the director doesn't feel that this is necessary, that he has other concerns, and so you could have came up with something else. But not working with the administration, and I've seen this in the past, where a lot of bills came up, and there's no dialogue, and so that's why as council members, for myself, for like almost like 6 years, I have a hard time, because when we have something that a council member wants, that you want, but then on the other side, the administration doesn't feel that there is a relationship, or that is like the timing or the request is not proper. And so I always see that, and it's a trend. And so that's why I guess it's sometimes hard. But to me, if there was more dialogue between you and the departments, I think that would be much better. And then we could come and pass certain bills that you come up with. So that's just a suggestion that maybe you can do in the future. Thank you.
Thank you, Mr. Onishi.
Yeah, I did after.
Yes.
This will be relatively quick. As the director said, there's actually three buckets. There's the rezonings, there's the subdivisions, and there's PUDs. I chose subdivisions to start with. I'm not saying PUDs and rezonings shouldn't have changes. I'm glad I heard Ms. Eoff say she's going to deal with that, because I thought I was going to have to go through all three. I just picked this one to start. I just picked one bucket to start with.
And I understand that, but the thing is, like, maybe it could be only on maybe certain sizes or something like that, or it could be exempt where at the certain parcels you don't have to, but to do all, I mean, it's not what, like as Ms. Willie mentioned, it's not feasible. And so that's where I think the dialogue needs to be, and that's how you guys can work out with something good. Thank you.
Thank you, Mr. Onishi. Ms. Willett?
Okay. Yeah, I mean, and let me say, I have amended some of Ms. Ford's bills, and I understand her frustration because she does do a great deal of work and proposes difficult issues, and we don't necessarily have what is a good answer. And when I gave it some thought, I wasn't quite sure how to define when to do it and when not, and I really didn't come up with a good answer. You know, I would be willing to postpone this, and at least if we were to change your language from shall conduct a site visit to may conduct a site visit, and we have these items where you've, you know, done a good job of delineating sort of the kind of issues that are sort of where it would be helpful. That would put the discretion to the director, and maybe at some point we're able to refine that better, but I think that would be a starting point. So I just ask the director, I mean, basically all what we would be doing is giving you the authority and sort of having something in here, and maybe also promote you know, people to request one. Hey, isn't this an appropriate time? So, I mean, if others on the council have brainstormed and thought of a good way to say which ones are and which ones aren't, I would be happy to look at that further stage, but at least perhaps we could get this language in here with a may. And I do feel, just from my experience as dealing with subdivisions, it's often where the problems do arise, where it's, so that's, I'm gonna yield to comments, but I would, or maybe I should just say I'd like to postpone this till.
If you're gonna do that, I would like to
Yeah,
comment before that.
I have no
happens to close it out.
problem with that, and just allow me the opportunity then to make that motion.
Okay, that's fine. Is there anyone else so I'll do that. I'll make my basically closing statement, and then Ms. Willie, you can have the floor back to make that. Is there anyone else wishing to speak before that happens? Okay, thank you. Okay, I think this is an interesting one, because we move from what we see as the rezones that are coming to us, right? So this is the process in which they get the entitlements. This is where we say, here's the density that you have. Does this fit in this area? The person leaves here with or without entitlements. Okay, they either get approved or they don't get approved. If they leave here with entitlements, we approve it. They are now entitled to do this. We have, as a council or whatever the body that says, you can now have X amount of lots on whatever size of property it is, right? So now that moves over to the administration. It becomes at that point, to me, and correct me if I'm wrong, Director Primo, it becomes their right. It becomes their property right. It becomes their entitlement. So if they have a 10-acre parcel that is zoned for potential of 5 lots, they have the right entitlement to come in and say, I'm going to subdivide my property, and they have to go through all of the steps that we have to go through, posting of signs, etc., having the right roadblocks in there, whatever it is, go through Department of Public Works, all of those things to make sure that curbs, gutters, sidewalks, etc. But as far as their entitlement is concerned, they're entitled to be able to subdivide that property into those lots as long as they can fit it within the criteria that fits there, drainage, etc. If there's a flooding issue, it's still possible, but there's other considerations that are made. They have to build it at a certain height level, etc. So that being the case, it takes it out of this realm that we tend to kind of cross over into like the PUD. PUD is not an entitlement. PUD is a variation, is a culmination of variances. It is the department being able to say, yeah, we can work with you on this, we can work with you on that. When we're talking about a subdivision, it is an entitlement, and I think the further we go to take away something that is out of the confines of what they have to do, posting a signage, complying with this department, etc., we could be potentially breaking the law in that, because as a council, they're entitled to do X, and then we'd be over there saying, go do a site visit. If you see something that is going to potentially be subjective, could potentially open up this massive can of worms, and that's where it's supposed to be handled at the rezone, at the entitlement process, which is why they do make the site visits. In all my experience in the planning commission, every time everyone has had a site visit, you're looking at it, you're trying to get the best view that you possibly can. Furthermore, if you're only going to do it on large subdivisions, is a person from the planning department really going to go out there and traverse through 100 acres? No. They're not going to find all the problems. They're going to drive to the property, they're going to look at it and see what they can see, take pictures if they can, but we'd almost be having to hire like a survey type crew to go through and traverse this property and say, yes, there's a ravine in the middle of it, there's this here, there's this. That's not, I just don't think that's our place to get into. We need to look at that from an entitlement standpoint, but once they're entitled, it's their lawful right to be able to do that as far as they can within our code. And I just don't see how having a site visit would improve that. Now, a site visit on a PUD is a completely different story because there's changes that are occurring. It's not an entitlement, a property right. It would be the same thing almost as saying, before you can build your house, before you can even submit your plans or whatever, I have to go do a site inspection. No, you do the site inspection after, while your house is being built. You're entitled to build a home on your piece of property. The same thing as if they leave here where the property's already entitled to do a subdivision, they're entitled to do that. And I think that's where these lines get crossed over, especially when it comes to subdivision. So I don't think that this is necessary. It would be open, actually, to me, to open up a larger can of worms in some of the other areas that we talked about. I do think there's a lot of room for improvement on there. And I don't even think fixing this by saying if it's a subdivision of X size, we have to have somebody that is a complete professional in that field to make those determinations. And those could be a multitude of determinations, you know what I mean? And it's just going to get messy. So I personally don't think this is the right place for this. With that, I will yield. Ms. Willie, if you want to make the motion, you're more than welcome to.
Okay. And I think everyone's brought up a lot of legitimate points, and this is really a matter of balancing these various legitimate points. Just in my experience, I've dealt with a number of...
Ms. Willie, I closed it out. You can either make the motion to postpone or not.
I want to make one correction. Not everything gets rezoned. It might be a certain subdivision occurring in what's already rezoned. Okay, Mr. Manager, I'm moving on. Okay, so I would like to make a motion to postpone this matter and bring it up, and with the intent of making an amendment. I would make an amendment as discussed before, and I will consult with the director we can designate the date or at the call of the chair. All right, I'll say at the call. Go ahead.
That's up to you to call the chair.
Call of the chair.
Okay, so you've made a motion to postpone this to the call of the chair.
Second.
Okay, it's been seconded by Mr. Onishi. Any discussion on the postponement? Ms. Willie?
No, I just encouraging it. I think I said enough to explain why. If you'd like me to restate or anyone has a question, I will. But otherwise, I'm up for, let's just go for a vote.
Okay. Let's do a roll call vote on postponement. Mr. Clerk?
Ms. Yao?
Aye.
Ms. Ford?
Aye.
Mr. Ligon?
Aye.
Mr. Kanuha?
Aye.
Mr. Nishi?
Aye.
Ms. Poindexter?
Aye.
Ms. Willie?
Aye.
Mr. Yoshimoto?
Aye.
Chair Kern?
No.
Chair Kern, you have 8 ayes and 1 no.
Very good. This is now postponed to the call of the chair. I'll look forward to sending that through to me. Take a motion to adjourn.
adjourn. Second.
Got a motion by Mr. Kanuha, second by Mr. Yoshimoto. All those in favor of adjournment, please say aye.
Aye.
Any opposed? Meeting is powered. We're adjourned.
Yes.